Contraception and birth control has been a hot topic in the United States for over 130 years, with the question of how much government intervention and in which way they should rule. The government has been going through a change, and it seems that it is making it a legal choice for citizens to make. The Comstock Law, which was enacted March 2, 1873, allowed the government to take control of the mail and made it illegal to send anything linked to the prevention of contraception. In 1876, it was amended, and every article or thing designated or intended for the prevention of contraception or procuring abortion is hereby declared to be non-malleable. The Comstock laws remained unchallenged until birth control advocate Margaret Sanger made it her mission to challenge the Comstock Act.
Margaret Sanger worked as a nurse throughout her life. Her mother had died of a combination of childbirthing and tuberculosis. Motivated by the loss of her mother, Sanger would later become an advocate for birth rights. As a nurse, Sanger treated the spark of her activism, Sadie Sachs. Sachs was a Jewish immigrant whose religion taught her nothing of contraception and was denied by physicians to aid in limiting the size of her family. Sachs then attempted to induce an abortion and died. Sanger then took up writing for The Call, a radical newspaper, to share her experiences. Under Comstock law, Sanger's article about venereal disease was refused for distribution by the post office, and she was then arrested and prosecuted for the education of women about their bodies. Charges were then dropped due to the death of Anthony Comstock. She then continued her campaign for reproductive rights and coined the phrase, "Every child will want a child." Her and her sister opened a clinic in Brooklyn and provided contraceptives known as diaphragms to prevent unwanted pregnancies and venereal disease. They were then arrested 10 days later for causing a public nuisance and imprisoned for 30 days. They were found guilty in 1917, and then they won their appeal in 1918. The courts then ruled that physicians were allowed to give information that would help prevent the spreading of venereal disease, but not contraceptive. Comstock law was eventually overturned. In 1907, Indiana became the first state mandating the sterilization of those seen as unfit for reproduction. It stated that those with believed hereditary problems such as criminality and mental illness were to be forcibly sterilized in order to preserve the rights of birth to those who could reproduce good genes. The laws were then passed in Michigan, Pennsylvania, Washington, and California. In 1927, the U.S. Supreme Court ruled this constitutional. The decision was in reverse in 1942 after reports about Nazi concentration camps became public. In 1943, reports indicate that during the relocation of 110,000 Japanese Americans, 9,066 women were sterilized without their knowledge at Tule Lake. In 1973 to 1976, the U.S. government admitted to forcing over 25,000 women living on Indian reservations to be sterilized. Today,
over 4 years, female inmates in California were illegally sterilized without the required approval from the state. The Center for Investigative Reporting says almost 150 women received tubal ligations between 2006 and 2000.
In the mid-1950s, men by the names of John Rock and Gregory Pincus had created what they believed to be an effective means of oral contraception and were looking for a population to test it on. The men decided that Puerto Rico would be an ideal location due to the fact that the country supported birth control methods to prevent population growth. The women the pill was tested on were mostly poor women who had very limited economic and educational opportunities. Rock and Pincus believed that if these women, whom they believed to be incapable of remembering to participate in such a routine, could, quote, follow the pill regimen, then women anywhere in the world could too. The trials proved successful for the two men, as the pill was proven to be 100% effective when taken properly. Yet the men overlooked large numbers of women who experienced side effects such as nausea and vomiting. The introduction and testing of the pill showed that an oral contraceptive could be very effective, but many Puerto Rican women were exploited in the Upon William Byrd's arrest for distributing forms of contraception to his Boston University students in 1967, a case was taken up by the Supreme Court regarding the issue. Typically only able to receive contraceptives from registered physicians or pharmacists, women were given few opportunities to practice birth control methods, especially unmarried women. Yet it was decided that the refusal to let unmarried women obtain birth control violated the Equal Protection Clause of the 14th Amendment, and was therefore decided that all U.S. citizens could receive birth control if they so chose.
In 1973, Roe v. Wade overturned Texas state law that banned abortions, with the exception of saving the life of the mother. Women were now able to get abortions up to the 3rd month of pregnancy.
There was an assumption that if you had a baby, if you were a mother, you were no longer entitled to pursue a career. Abortion rights meant symbolically that women did have choices. Women could say, not now, later, or not at all.
Doe versus Walton ruling made it legalized in Georgia to have an abortion at any time during pregnancy and for any reason, expanding the term health, anything harming the mother's physical, psychological, mental, and emotional.
Before the 2007 trial of Gonzalez versus Carhart, the law of 2003 known as the Partial Birth Abortion Ban Act was in practice. This meant that doctors were legally unable to perform an abortion within the second trimester of pregnancy. At this time, 85 to 90% of the annual 1.3 million abortions performed were within the first trimester or the first 3 months, and were not covered under the Partial Birth Abortion Ban Act. The purpose of this act was to limit the abortions that occurred during the second trimester using the dilation and extraction methods. In this form of abortion, doctors would dilate the mother, extract the torso and legs of the fetus, and then suction the brains out in order to pass through the cervix more easily. In the case of Gonzalez versus Carhart, the U.S. Supreme Court upheld the act as constitutional, therefore banning all second and third trimester abortions, regardless of whether it was done to preserve the health.
The Affordable Care Act requires all for-profit, non-religious companies to include contraception coverage in their health insurance plans at no out-of-pocket cost to women. The problem today is that U.S. court system is divided on how the Affordable Care Act should be used. The 10th Circuit Court of Appeals says that the Christian-owned Hobby Lobby should not be subject to fines for not complying with the requirement, while it argues the birth control rule in court. The Supreme Court is likely to take on one if not all of these cases to set a precedence for the rest of the country to follow. Throughout the history of the United States, the government has taken major roles in dealing with contraception and birth control. However, government stances on these issues have changed and are still changing today, with what seems to have no end in sight to the constant struggle on these moral issues.